Hi, so I'm here to talk about the GDPR, and I assume that the people here who are interested in it know what the GDPR is. It's okay if you haven't. Not everyone has to at this point in time, but if you haven't heard anything about it, well done for coming. And if you really have absolutely no idea, I'll be the one to inform you. 2016 GDPR is an asteroid on its way to collide with mainland Europe on the 25th of May 2008. So you've got about a month to go. In an astonishing coincidence, the European Parliament also passed a law called the GDPR, and it is set to take effect on, and I'm not making this up, on the 25th of May 2018. So you've got about a month to go for that. For my own sake, I'm going to ignore the asteroid completely and just focus on the hypothetical peaceful life in the European Union afterwards. Also, I'm an Australian, and I'm probably going to say data, not data. There's nothing I can do about that. I'm going to try my best. So what is the GDPR? It basically regulates the processing of personal data. You've probably already been doing this for a while because we already have laws that do that. This time round, it seems to be a little bit different. The scope and the enforcement of the laws is dramatically increased. For example, the punishment of the 4% of your global annual revenue is scary, and so more people are talking about it, taking it seriously, and we're here where we are now. The other bit that's very interesting is that it's a regulation, and the old one was just a directive, so it means that all over Europe, it's exactly the same. It's the same text translated in several languages, whereas previously each country had their own little legislation and they had their own little authority to control it, and they may or may not have been very serious about doing that properly. As a user, this is actually quite wonderful and much needed. And because of the recent happenings with Facebook and Cambridge Analytica and so on, we're all starting to see that this is actually quite nice. You may have already had this warm feeling of trust when you've been seeing these consent forms explaining to you in full detail, in plain text, what they're going to do with your data. And you feel that you have this knowledge that it's going to be deleted whenever you want and everything is happy. Not sure if that feeling is valid. The GDPR, feel free to read through it. It's not too hard to get into. It's a larger document, but the beginning is some recitals. They're not part of the law. The first 30 or so pages. Then we have some articles, which are the binding bits. Only the first 34 are really relevant to us. After that, it starts setting up some regulatory bodies and and we'll go through some of these sections just quickly, so you'll have a clear grip of that. And then towards the end, there are a couple more that are slightly interesting, but it's not too scary. It is accessible. The ICO website has, in the UK, has a very nice sort of introduction to a lot of these things, and I'm sure you'll hear about it lots in the next time. I'm here to talk not to managers or people running companies. I'm here to talk to developers, data scientists and engineers. And for you, you've got it a little bit more relaxed because you're not personally reliable for anything under the GDPR. Your company is, if you're an employee. If you're a freelancer, you are, I'm sorry. But if you're an employee, you'll be fine. Basically, it's up to your company to train you, to give you these skills and knowledge, and they're the ones that carry the responsibility. What I'm going to do is I'll give you a quick overview of what I expect professional software developers or data scientists to be doing, and what was just mentioned before. I think there is a professional duty for anyone who calls themselves a data scientist or a software engineer to get to know these rules of engagement, these rules that define how you work. It's not a legal requirement to know this, but I think it's a professional requirement. And we don't have that formal requirement as doctors and lawyers and other professions do. And I think it's a shame. But I think it's good, and it also makes you a little bit more valuable to your employer if you are someone who does know all of these things. More importantly, though, is that this really helps your employer comply with the legislation, with the regulation, because you're in a position where you know the data far better than the people who make the decisions about the GDPR are, and you'll see a lot more things that they'll never see. And you'll probably also understand how your algorithms and data works, and you'll be able to notice a lot of areas where compliance may disappear. So what I will do is I'll go through those three things that were on the board but not there anymore. Basically the terms, or just basically some concepts that are in the legislation. You'll get to know about all of them. Personal data, processing, data control, all that sort of thing. I'll go through some of the rights that users have, or you as well as a user when you're using other sites. And at the end, the last third, I'll be looking at some tasks and things that actually we have to do and we have to know about to do differently. When looking at terms, I think one sort of thing to think about is that there are no clear answers for what is personal data, what is a controller, and this and that. Some are more clear than others, but it's not really like programming. There are no types, there are no sets of sort of data where you say a name is personal data and a religion is... It doesn't really work like that at all. In law, you sort of have to argue for one thing, or you can argue for another. Sometimes the context means that this is personal data, sometimes it doesn't mean it's personal data. So when we do look at personal data, what is it? It's a very, very broad definition that just says any information relating to an identified or identifiable natural person. So it explicitly mentions indirect identification. And there are some examples later on that talk about things that you could identify someone not directly but through other factors. And it also mentions in a longer definition in this section an online identifier like an IP address, like a device code, like your cookies. They all qualify as personal data because you can use them to identify somebody. Names can sometimes not be personal data. They mostly are. IP addresses can also not be, but they mostly are. It depends on a case-by-case basis, and you'll know it when you see it because you'll ask yourself the question, can it identify someone? The data subject is just what we call the person whose data is the personal data. That's a pretty simple one. Processing comes up a lot. What that means is really broad as well. That's basically... any of this, so collecting, recording, organizing, structuring, storage, adaptation, I mean anything you pretty much do with data. Note that it doesn't cover everything, and there are a lot of exceptions. For example, if you write some notes, if you don't intend to file those notes, then that is an exception. You don't need to concern yourself with a lot of that. Basically, think processing is anything you do with personal data. Also note, well, I mean, when we talk about a data controller, I guess that'll come up. A data controller and a data processor, which is after that, those are the two entities which do something with data. So the first one is pretty much the one that takes the data from you usually, and they sort of control the purposes of what they're going to do with it. And the processor is just someone who works on the data. There are exemptions as well to this one. For example, just your friends sharing phone numbers. If it's purely personal, that's not going to be a problem. You're not a data controller. You're safe. And if you're something like a freelancer, then you're also not a data controller because you're just working with your client's data. This is also very broad. It also includes people outside of the EU who are working on European data. That's also not a concern for us technical people. The data processor is like a freelancer. I will be a processor if I work on a client's data. They are the ones who are controlling it, but I also have some obligations. Less obligations, but some obligations. Special categories is the second last thing that you probably should know about. What these are a broad range of sensitive personal data things. So, for example, ethnic origin, political opinions, and so on. You should get to know these because you'll need to recognize them. You're probably the only ones that will see if this data sneaks its way into your system. Also notice that the word revealing means that it's not always direct. The data may sort of slide into your system because something else will reveal it. And your bosses, anyone who's in control of running the product and this and that, may not know about this happening. It may only be you who can see it. And you really should. There are, of course, exceptions and this and that, but you should maybe flag it and let the people know about it who want to know about it, that it's happening. Data that comes under this will have have some extra requirements for storing it safely, separating it maybe. And also, as we'll see to the end, automatic decision making cannot discriminate using any of these categories. Profiling is the last one. That's just a special form of processing that's called out by name. It can have effect on transparency requirements. It's not too important for us as people working with the data, but it is something we sort of need to get to know about. It is what it is. You're analysing data on a person to predict or analyse their performance at work, economic situation, health, preferences. That's also very, very broad. Pretty much, I struggle to think of an example that isn't profiling if you're predicting something about somebody. If you come up with one, let me know. It's deliberately broad, and it has a few other meanings in the law. If you get to know that, it'll help. But moving on very quickly, because I want to get to some technical things. Here are some of the rights that users, that us, when we're a user, that we get to enjoy. Transparency is what you may have already noticed. The company is telling you what they're doing with the data from which you didn't know about before. And this is really fun to sort of read these disclosures. They're in plain text. They're very short and simple, and you have to explicitly consent to them. This is all wonderful, but not exactly our concern. You can sort of see some companies testing the limits, and there'll probably be some litigation on that later. It's not so much our issue. Access to data is also, as a user, interesting. We get to see what they have on us and download it and this and that. It's not quite, in a data science perspective, not quite important for us, but we can... I will talk about this more at another conference for web developers. So if you do web development, it can be something for you. You have to allow your users to rectify, to correct data that's wrong. You have to allow them to erase their data on request. That is, if they remove their consent or they object to it, if you have other reasons for doing it. You have to think about whether you can do that, whether you're able to delete just a single user's data throughout all of your systems on request. You've got a month to do it if they ask you to. Data portability is the same thing. This is more interesting, and I wonder what that'll end up being. You have to provide your users or your people, data subjects, with their data in a structured, commonly used and machine-readable format. Have fun. When you... there is also maybe the requirement that you send it off to another provider if you're in a web development context that's more interesting to you. You have to be able to restrict processing of data. If someone says, please don't continue processing that, you'll have to have some flag or something to stop that single bit of data being used, but not deleted. There are the possibility that someone requests to be opt-outed of automated decision-making. You have to allow that. Good luck. And the right to object is, I guess I should have included that in erasure above. It's the same sort of thing. But it's another legal situation where that arises. Now's the more interesting bit, the bit about the things we have to do, the way our job is changed. And a lot of this isn't clear yet. The law is new. It hasn't even happened yet. But no one really knows exactly how it'll be interpreted. A lot of the things are a bit broader than they were before. we're going to have to suffer a little bit in the changeover. We're going to have to do things that are uncomfortable and maybe rewrite systems or learn new tools or write new tools to manage our data. And it's going to hurt us a little bit, but I guess in the future, in 5 years, this will all be a bit more commonplace. It'll be easier. We'll know exactly what we'll need to do, and we'll know the best ways of addressing a lot of these things. One vague requirement of the law is privacy or protection of data by design and by default. That means that you have to be good at what you do to use state-of-the-art encryption and do things properly and separate your system. What that sort of means is, I guess, to separate your personal data from the rest of your system. That's the easiest way to do it. To not sort of mix personal data within the rest of your business logic helps you protect it a little bit. That's one way of designing your systems to work with that. Encrypt sensitive data of those special categories so that you don't accidentally pass that around the company. And maybe track the purpose for which you got consent of a lot of this personal data. It's not clear exactly what that is going to entail, but you sort of have a vague idea as someone technical how you might be able to make sure personal data doesn't fly around the system in plain text. I've already said all of that, I believe. Yeah, exactly. Erasure is then the same thing, the same problem. Someone comes to you and says, please remove all of my data. Can you do that? If you're developing a system, you might have backups of your data that get automatically encrypted and sent somewhere. Can you remove a single user from that data? Not so easy. But if you're separating your personal data from your other backups, there may be ways of doing that. You have 1 month to react. If you have database dumps, you probably don't need them for 28 days. A database dump is a way of very quickly putting data back into a database. Do you need to do that 28 days with old data? Is there a way that you could maybe just remove the personal data from the database backups? And in that case, just delete the personal data after 28 days, or archive it in a machine-readable format that you have to give the users anyway. Try and automate some of these things. Try and work it into your workflow. If you're a data scientist, you might be working with systems that aren't always your systems in control of. So I guess you'll have to have your own ways of doing this. But maybe if you do get too much data, if you do get all this sensitive data, when you're trying to work on something that has nothing to do with it, you could ask questions about why you've been given this data. You probably wouldn't want to have it. If you encrypt the data per user, note that encrypting something and throwing away the key is deleting it. And if you encrypt backups per user, you don't actually have to change the backup, you just throw away the key for that user. And it means you haven't messed with your data in any sense, you haven't had to edit any of the data. If your system's also like that, you can do exactly the same, and you've managed to delete something without changing anything in your system. Moving on to something that we just heard about. Discrimination via Article 22 is now banned for the special categories. Now, this isn't everything that is discrimination. The special categories are the ones we had before, racial, ethnic. Something that's missing from there is sex and age. So you're free to discriminate with your shoelaces. You're free to write pricing algorithms. If you automatically come up with those, you're not going to be hit under the GDPR. You'll probably be hit under some other anti-discrimination legislation. Which is, I think it's just a bit lazy that they reuse the same categories for discrimination as they were for special sensitive data. But, again, the important word here is revealing. And that sort of suggests that this might be indirect discrimination as well as direct discrimination. As was mentioned before, a postcode can be revealing of race and so on. It can also be personally identifying if you combine it with a birth date or something like that. I'll talk about that in a minute if we get to anonymizing data. But if you discriminate based on if you avoid discrimination directly based on your protected categories, you may end up in trouble because of things like intersectional. So my data doesn't discriminate against race or against gender, but gender is not included. But if someone happens to be in both those categories, it may end up being that your algorithm is discriminating against those people, and that's not allowed. So if you are testing your systems for discrimination, make sure you don't forget intersectional categories, because you may miss them. Be careful of uncertainty bias. A lot of minorities may be underrepresented in your data, and if you have sort of like a risk-averse system that sort of sees this uncertainty and then denies maybe a loan application, then you're going to be in trouble, because all those people in that minority are never going to have the certainty in your model to get over that hurdle. With indirect discrimination, that's tricky. Like that is, and I hope you're all paying attention in the talk before me, because it is very hard, especially with large data sets, to avoid discrimination creeping through other unrelated, seemingly unrelated attributes. One way of maybe tackling this, or there are several ways of tackling this. One way of tackling this may be auditing, maybe having an external person with access to the protected categories data, because you haven't collected data on race and gender and so on. Another way is to maybe make trade-offs. As was mentioned before, discrimination doesn't cost the world. It is not very nice to have a completely unfair system, and if it only costs you a small amount of optimization, then it's probably not worth it, and that's a problem of multiple optimization. If you include it in how your model evaluates your data, then maybe it will be sort of included in that you don't discriminate. Again, a problem with that is that you're not collecting data on race, you're not collecting this data in the first place. It may be difficult to audit yourself. It's hard to say how this will be enforced, and we can't really predict that now. And I think in a few years it may be a bit clearer to what extent discrimination is a problem. One thing is class actions are possible under the GDPR, so this enforcement can be very heavy. And it's not just controlled from above. It can be some people really notice that your algorithm is discriminating against them, and they're able to launch class actions. Also, if I go quickly back to the discrimination, this is only for discrimination is only for completely automated decisions made by systems. If you write your systems in a way that allows the user to be opt-in to have a person involved in the process, then you might be able to reduce the discrimination. It's hard to say what's required of you, and that will be clear in the next few years, but be aware that this is something that you may have to think about, and if you attend conferences like this, you're in a good position to address that. The next one is also very interesting. It may be that there is a requirement to explain decision-making, this automated decision-making. It's not clear if that's the case. There's an argument for and against that, as lawyers like to argue. It's not going to be this or that. I'm sorry, it's not going to be clear for a while. But I think it'll happen pretty quickly. There are a few companies that are pushing the limits, like Schufa in Germany, and they'll be sued very quickly, and we might get a result on how much explaining we have to do. But of course, if you have a nice neural network with several deep layers, good luck trying to explain to the user how you came up with that decision, especially if the decision was made a long time ago. There's no real time limit that's obvious that the user will come and say to you, okay, a little while ago you made this decision about me. I'd like you to explain what happened there. Are you able to explain a decision made 6 months ago? This is an emerging area of research, and it's exciting, and it's sort of interesting to see how clever approaches do that. Again, it's really not clear if that is a requirement, except if you're in Germany, it is a requirement. They have a special law that increases the coverage of the GDPR, and there you do have to explain. It's not clear exactly what you have to do. There already existed a rule like that. Schufa, the credit agency I mentioned in Germany, they got around that by having a token person involved in their process who pushed a button. And so it wasn't a completely automated process, and they were able to get away with not having to explain what they're doing. Some people in Germany, where there definitely is that explanation, say that you roughly maybe have to include the top 4 reasons or most persuasive parts or attributes or what was relied on to make the decision. This is all really hard to do for some particular types of machine learning. Again, you're going to have to wait and see a little bit, but be prepared. Get to know this emerging area of research, to see how your systems might be able to come up with explaining something. You'll have to speak to the lawyers about when that will actually be very required of you. Anonymizing data. So one interesting thing is, if you anonymize your data, it's no longer personal data. And it means that the GDPR doesn't apply anymore. So beforehand, if you collect data with a specific reason to purpose to use the data, you can only use it for that purpose, or if you can think of another legal reason to be able to use that data. That restriction is removed as soon as you anonymize the data. Sounds all nice and easy, but anonymizing data is actually very tricky. If you're not an expert in this, or you haven't really had much to do with anonymizing data, don't try to do it yourself. Learn about it, or find an expert and get them into it. Basically, the test is if re-identification is reasonably likely, and you are the people who are probably the only people in the organization who will know if it's reasonably likely to be the data to be re-identified. The lawyers or other people involved in your GDPR for your organization may have no idea how this is, when this is going to be a case. Again, you'll know that you'll have to be careful if you're adding data sets. You can suddenly re-identify data you thought you'd anonymized. Facebook wanted to get some medical data in the US because they knew they were able to re-identify it and link it to their existing data set. You'll have to assume that anyone who does, if there is a data breach, that they will have access to other data sets when you try to anonymize. It's, as I said, especially for machine learning where high dimensionality is very common because we can now. This is hard. This is really not going to be an easy thing to do. What can you do about it? Well, if you don't know what those 3 things are at the top, then you shouldn't be trying any of this. You should find someone, and there'll probably a lot of people in this room who can do it for you, or learn about it. But in general, you can try things like suppression and generalization. Avoid outliers, as they can reveal things, but they're also, outliers are bad for your model as well. They can cause overfit. They can so a lot of this anonymization can actually help improve your model. Get help, I guess, and build it into your systems. If you have, if you work a lot with different teams and different data, maybe find automated ways of getting access to data that already caters for anonymization through automatic processes that can analyze it and then give you or your data process that you're handing the data off to some data that's a bit safer to use. In terms of specific requirements of the law, basically if you start wanting to use your data for anything, for any purpose, you'll need to anonymize it, and that's the freedom it gives you. Breach notification is pretty easy. This is something you need to know about, because if you do notice any unauthorized or accidental breach of your data security, you need to have it notified within 72 hours. This depends as well on this and this and that, but just make sure your lawyers know about it so that someone can do the notification, because if you tell nobody, if you don't tell your superiors, you may put your company in breach of the regulation. Basically, that's all I really had to sort of quickly say about these issues. It's not in depth, it's not giving you all of the answers, but it just gives you a feeling for what you need to care about. learn some of those topics at the beginning and get to know some of the rights and the tasks you have. You sort of know where you can look for more information. Try not to do everything yourself. And good luck, because nothing's really clear at the moment. And it will be maybe in 5 years, but we're the ones who are going to suffer the most right now. Thank you. Cheers. If there are any questions, I'm not going to answer questions on compliance or help you comply in any way. But if you have general philosophical questions, I'm happy to.
Thank you. I work with open data quite a lot, and even if you don't work with open data, you might have data that you've collected with consent but then published in a form that other people can download. Does it apply to that, and does one have to be able to be... Can a person ask to be deleted from open data sets that they've consented to be part of but are now distributed?
Tricky question. It is a little bit on compliance, but if you are processing data and you didn't really collect the data or determine the purposes, then you're a processor. So the data subject doesn't contact you directly. They contact the controller, so whoever collected the data, and they have to contact you to erase the data. But you still need to have legal justification to work on that data. So ask your lawyers to look through the sections that give you the legal justification. That will be either explicit consent or if there's a reason. There are the possibility of data archival people or journalism that could be exempted, and that is in the local laws, possibly. But you'll have to check that for your specific situation. It depends. But generally, if it's anonymized data, it's not personal data and you're free. Okay. But it applies to all data. It applies to anything all personal data that you can identify somebody with, unless there's an exception, if you can't identify it anymore. Yes?
Hi. Yeah, thank you for the talk. My first question may sort of breach into the compliance issue, but I'm assuming that the sort of explaining why decisions were made doesn't, like, just saying that, well, we used machine learning and it told us this is not really a valid explanation. So can you say anything about what that sort of, what kind of form should that explanation take?
Yep.
And then the second question is, do you see any unintended consequences from GDPR that may arise?
What was the example? Sorry? What was the example?
Do you have any can you see any unintended consequences that could arise from GDPR? Maybe.
So for the first question, that was about explanations and what that looks like. Nobody knows. It's not clear whether it's a general explanation, like this is basically how my system works, we take in these categories and that's, or if it's a specific explanation, this is your decision and this is what we use exactly for your decision. It's not clear. And it's most difficult, especially when you're using machine learning, because it's very hard to do. I can't really say what's going to happen. We're going to have to find out, and I'm sorry that it is that way. In Germany, it is a little bit more pronounced because they were specifically saying there is this right of explanation and it's going to look like this. It may be that there is no right to explanation because it seemed to have been deliberately left out of the specific article that was mentioning it, and it may have been a little bit of politics that led to that happening.
It's very useful to know that because I live and work in Germany.
Oh, got you. Yes. Question in front of you, just on the right. Yeah.
Thanks for the talk. What happens to data that is personally identifiable but that is put on a public website and then gets taken down? What happens then? Does anybody that has ended up reading this data and possibly saved this data need to immediately delete it from the data set, or what happens?
Yes, they should. I have no idea how that works in practice. But basically the controller who put the data up on the website has to make sure that anyone that they gave the data to also deletes it. In reality, it's tricky. I have no idea what that particular situation, how that will play out. We'll find out.
Thanks for the excellent talk. Are local courts going to enforce this regulation, or European tribunals, or how will it work?
I couldn't hear quite clearly. Our local
local courts. So is it going to be the European tribunals that are going to deal with this, or national courts?
Well, it's both. It will be in local courts, but I think previously the data controller could choose where it was, and they all chose Ireland, where it was very difficult for people to attack some of the controllers doing that. But now you can have it done in your local area in Germany or wherever you are, and that makes it a little bit easier to access the courts for that. Each country has to set up their own authority that will help enforce the laws, and that's slightly separate to the courts, but they have to be well funded, and that's something that's also going to change because the old laws were very laxly enforced, and especially with the lower fines, it wasn't very convincing. But now, because of the fines and the class action and the courts being chosen everywhere, then it makes it a little bit easier to enforce it.
Thank you for your talk. I have a couple of questions. So the first one is, when it goes from a directive to a regulation, normally each country have to vote and put it into law, right? And this is, all EU members have done that?
Yes, so it applies to everywhere all at once on the 25th of May, but each country usually would probably also add their own. There are a lot of sections where they're allowed to add something to the legislation. But I think only about 4 have done that. Okay. It hasn't really happened so much. Germany...
I don't think it's going to happen in 1 month, right? Unless you get all the assemblymen back.
It may or may not. I have no idea what's going to happen. But the regulation applies everywhere anyway, so they don't have to enact legislation to make it happen. It's going to happen. But they can choose to go further, and Germany have done that in some sections, and I think the UK have done it as well, and France, and I'm not sure, Italy or something like that was the other one I know about.
If I may, I have a second question.
Yep.
Certain type of things, like let's say you buy something, and the sellers are required to keep your information of you.
Yes.
Because certain things are controlled.
Yep.
Obviously, in Europe, guns are not there on the list, but things have to be kept. Now, when you invoke your right to forget, are they required to remove them? Because now you have a big conflict right there.
Of course, there are exceptions, and one exception are for to comply with your local laws or for accounting processes and things like that. So when you do erase, and I should have mentioned this earlier, you're not erasing all of the data you have on that person. You're just erasing the personal data that's maybe not related to your accounting or transactions. And you do keep the other stuff, and you're allowed to keep the other stuff because you need to have your systems, your accounting systems working, and so on. Yep.
Thanks for the talk. There was another talk recently that talked about the using companies' house data. Is that data somehow exempt from the GDPR?
Sorry, which data?
Company house data.
Company house data. You mean by archive?
By, for instance,
public
directors of a company, because you normally can find, address and that sort of thing. I think it's similar to question.
So the personal data is only for natural, like for people. So companies are not covered by this. You can have any information about them in any form or sense. Is that what the question was?
The directors.
The directors. I'm not sure, and I imagine no, because there'll be, well, I can't say the reason why, but I imagine not, because of an exemption that it would be dealing with local legislation and things like that.
Last question.
Let's say a country voted to leave the EU. How much uncertainty is there around how much of GDPR is going to stay?
It's up to the country who decided to leave it, what they're going to keep. And I've heard they're going to keep all of the laws at this time. So I guess it'll be the same as it is for now, and that might change, assuming the country does leave, if it goes through with it.
Okay, thank you very much.
Cheers.